here for someone has a computer on with, there we go. All right, we are here on a continued hearing for file S as in Sam 001-25 subdivision preliminary plat for Deerfield. This was already heard, and there were 2 commissioners present. Now there are 3 commissioners present, and so with that, we'll call for conflict of interest.
Commissioner Domke has none.
Commissioner Williams has no conflict.
Commissioner Corn has no conflict.
And so before we jump into it, let's have some direction on how we want to proceed, given that this is continued after it was already presented. And I think there have been a couple of tweaks. So with that, let's start with our Bill Wilson. Do you want to give some direction?
I think that planning staff
Or-
is probably going to help.
They're trying to sit far, they couldn't be farther away from giving a comment, so you sat up front.
Sure, so Bill Wilson for the record, Bonner County Prosecutor's Office. This is a continuation of a previous hearing, and so it should be limited in scope to the subject matter that the commissioners at the previous hearing asked to receive more information on. So we'll try to do that, and I think the staff will be able to address that. And as long as we keep that within those parameters, that would be my guidance to you. And also, Jason, if you have more contribution on this, happy to hear it. Do you guys have any other questions for me right now?
I think it's worth clarifying. When you say limiting the scope, you're referring to additional information in the record and public comment?
That's right.
Because the board has not deliberated on the full files. So.
That's right. So at the conclusion of the previous hearing, I think Commissioner Domke requested some additional information on that he wanted to see on the plat, and then also on the base flood elevation and some communications that had been either sent or received or requested with the federal government. That was the subject matter that you wanted more about, to know more about. But the board did not actually get into the worksheet or any of the deliberation. So once we close the public comment and you guys begin deliberation, you will need to go down the entire worksheet.
So I'm going to do an additional clarification to you, because I was the commissioner that was not here. So is there a restriction on the questions I asked pertaining to the file from top to bottom as I have reviewed it?
Yes, because you weren't present at the last hearing, you forfeited the right to, you can't. Under the notice reason for this hearing, we did notice it with that and the motion that was made to continue to today.
So the way that this is reading,
Okay.
but I do have to say, please no outbursts. It's, the way it reads is, applicant is requesting to subdivide a plat and approximately 32.67 acre parcel into 24 residential lots ranging from approximately 1 to 3 acres each and 1 stormwater tract. The property is zoned suburban. The subject property is located off Baldy Mountain Road and Section 16, Township 57, North Range 2, West Boise Meridian. The project is located within the Syringa Heights Water District and Northside Fire District service areas and the area of impact for the city of Sandpoint. The Board of County Commissioners at August 14th public hearing continued this file to September 9th. They do not give a restriction on the continuation in the notice. So I'm being specific on clarification because I was out during this time and I want to make sure that my participation doesn't negatively impact, but equally, I have questions on this file. So I want to stay within the bounds of what legally you're saying should happen since they did not deliberate on this file.
Didn't deliberate. I do recall, and Commissioner Domke, please correct me, I thought we went over the scope of the hearing when we made the motion to continue. Is that correct?
I believe we went over, and we can look, I believe we went over what we were limiting the scope to for the record.
Right. So I believe that the notice just provides people with the opportunity to know to be here, what the subject matter is. Even if it wasn't specifically limited in the notice, that doesn't prejudice anybody's rights. They still will be able to participate for the limited duration or for the limited scope that the board intended at the meeting. So I think you should be able to limit the scope the way it was intended. That's the way we always do these continuations. And whether or not the notice specifically limited it that way, don't think that prejudices anybody's rights.
In the deliberative process, any board member is allowed to ask any question of anybody at any point in time. Are you saying that I would be restricted from asking a question outside of the scope of which you're saying this has been continued for?
Yes. The reason for that is because we have to consider not just the due process rights of other people who might want to go back and relitigate those issues, but also the applicants themselves. They might not have been, I think, the expectation was that we would have a limited scope of hearing here. So if you opened up the entire file again, so to speak, you might encourage an accusation that we, let's see if I can explain this properly. Just that it would give the applicants the right to claim that maybe we went outside of what we told them we were going to do. So I would still recommend that we limit the scope of the hearing as was originally discussed.
Okay. All right. It's a question that I have of then, okay, all right. So I'm going to lead with, since Commissioner Donkey had the request of things we reviewed, then we'll start with you of asking your questions for consideration.
Was staff going to present or ask the applicant to present the updated information, or?
The updated information was placed in the commissioner's file.
Correct.
And frankly, was very minor. We have some topo.
Can I
We have some
have to
adjacent
pause one
landowners
second,
now.
though?
That's all.
We need, do you want to give him the microphone?
Sure.
If he's going to answer, so that we can have it on the record, please. And then state your name and position, please.
Jason Johnson, Bonner County Planning. We didn't come prepared to make a presentation because the presentation was made last time, and the updated information is extremely minor. It was only a code. Frankly, it's obsolete code that required it, but it required it, so we required it. Things like adjacent landowners and a sanitary restriction lift and adjacent landowners and the topo. We already have topo and adjacent landowners. We don't really need people to put that on the plat. I can find that out at any time. That's also public record. Anybody can find that out. But the code says it, and they didn't do it. So there was a condition that they do it, and they've submitted a new plat. They addressed 5 of the conditions, which is the maximum they could reasonably be expected to address at this point in the preliminary process. There's no way they could fulfill any of the other conditions that are on here.
Director Gabel?
Yeah, Jacob Bell, Planning Director. So just to clarify, Bill mentioned notice for this hearing. It was continued at the previous hearing, so we didn't do a new public notice. All we did was added it to the agenda for today. So typically, when a file is continued, we don't do an additional public notice. Essentially, the notice is provided to the affected parties at that time in the hearing when it's continued. But in that, it was limited in scope to what the board left the record open for, to receive additional information based on the concerns the board expressed at the time.
Can you refresh my memory that we said there was a point in time when we were a tie of 1-1, we were offering a redo for the third commissioner to sit in. Is that still where we're standing on this?
So I guess I'm asking for clarification.
When it's a tie, one direction says yes, one direction says no, and you only had 2 votes, weren't we saying to the applicants, we'll hear it again?
So we didn't have a tie vote. Both the board members.
I'm not asking about this case, I'm meaning historical. We have had a case where we have tied a 1-1, and then we have heard it again. And then we address the issue of what do you do when you have a commissioner that says yes and a commissioner says no, and you didn't have the third commissioner, which essentially breaks your tie.
Yep. So that requires an amendment to to Chapter 2 of Title 12. That amendment's been processed. It's going to hearing next week with the Planning Commission, so it should be before the board here in the next month.
So we're currently not done with that.
Correct.
And so in the event that you proceeded with a vote without a third commissioner, and you had 1 for and 1 against, we would hear this all over again.
I think a tie vote of the board is not a final decision of the board, so it's a lack of decision. So the board would continue to have to deliberate until a majority of the board decides on the file.
Okay.
Right?
That's right.
I think you see where I'm going with it. I wasn't part of the first one, and so you're saying what I can ask a question on. And so I'm trying to address being fair and equitable on both sides of it, because when I read this hearing notice, I went from top to bottom. of this whole file. And so unfortunately, I had an unplanned surgery and was gone during this one, but I've read it. And so if I'm not going to be able to ask any of my questions that I would ask in the hearing, is it more reasonable and appropriate for the two commissioners that had this hearing to actually have to cast a vote? And if they come up with a tie, then you go back to, then you put the third commissioner in. I'm trying to make it reasonable, because when I thought I was going to be able to ask questions, this was noticed as if it's a continuation without, there's no deliberation, there were questions asked. So that's where I'm trying to understand what is the most reasonable way, because I would be casting a vote without questions answered that I have on the file because I was not present for the first hearing. So is it more reasonable that the two commissioners that sat in that hearing cast a vote?
No, I don't think so. I think if you were unable to participate in the first hearing, whether by your choice or not, in this case it wasn't your choice, you forfeited the right to, and in the context of a continuation by one of the commissioners who was present, you forfeited your right to ask questions on those topics. But you're here now, you've read the entire file, you have access to the record that was already created from the first hearing. And so you're essentially bound by the questions and deliberation, or at least the public comment on the topics that were covered in the first hearing. And you have that record in front of you, you can make a decision on that. You didn't have the right to ask, or didn't have the ability to ask questions, but you still have the record available to you to make a decision, and you're here today. So I think you do need to make a decision, and you have the same right today to ask questions on the limited scope of this hearing that the other two commissioners have. I don't think it's appropriate, though, it's your decision whether or not you want to participate, but I think there's nothing stopping you from making a vote right now.
It's limited questions is what my issue is I'm limited to the continuation is what you're saying versus the full breadth of the case. There's a lot involved with this particular case on that exists, but I hear your issue, so let's just move forward and we'll see where we get with it.
So if I'm understanding correctly, Bill, you're saying that because we left the record open limitedly, that the applicants are limited in their presentation to the board. So that's what I would suggest, is we open it up for the applicants to provide an argument for the record, or for what they've supplemented the record with. And then you open up for public hearing, limited in scope to what's been added as well. Exactly.
Yeah, I understand what Bill is saying. I was being specific to my absence at the fuller hearing and coming in at this stage, so. Okay, so staff has nothing to report, so we'll go it over to Mr. Rodriguez. Do you have something to present regarding the information?
He's going to present on behalf of the applicant.
Either one's fine.
Yep.
Good afternoon, Dan Tadek with HMH Engineering. Since last time we met, as Jason articulated, we have submitted some additional information to the county. Primarily, the plat was updated to account for property owners, adjacent property owners, some topographic information. There may have been some other minor kind of formatting type adjustments on the plat. We also submitted there were a couple outstanding comments on the stormwater report, primarily that erosion sediment control and a geotechnical report had not been submitted. So those were since submitted as well to address that issue. And in regards to FEMA, I believe the last time we met, we had spoken about the response from FEMA and then the fact that they had asked for some additional information. That additional information was provided to FEMA on August 20th. On August 27th, and I say FEMA, there's actually a consultant representing FEMA in this case, but I'll just read to you the email they provided, confirming that I was able to download and open the submitted files. I'll get back to you within the next week with an update on if there are any outstanding issues. That was the 27th. Today is the 9th. More than a week, but we're on FEMA time. So unfortunately, no additional information from FEMA at this time. I do not believe there were any other updates to the file. There was a memo that was submitted as well that updated a little bit about the process and then specifics about Bonner County Code regarding when a submittal to FEMA was required in the process, specifically as a requirement prior to preliminary plat approval, and that the adjudication or the response from FEMA is a condition of building location permit. So we just added that to the file, just citing Bonner County Code. But other than that, I don't believe there was anything else that we submitted since the last meeting.
Were the, I thought the road and grading plan set was also,
Yes, they were updated in final form. Really, what was lacking in there was the erosion and sediment control plan. But yes, I guess the full final road plans were submitted.
All right. Does the board have any questions for the applicant? All right.
Thank you.
Easy.
actually, I would like to ask, I'd rather ask it as a question than just make it a comment later. When you guys updated the preliminary plat, one of the things I had noted in the last hearing was what I perceive as the inaccuracy of the match line. I don't see where that's been corrected. Has that been looked at?
It's really more of a matter of taste than inaccuracy or incorrectness. That's not atypical with how plats are produced and recorded in regularity. We've got a licensed Idaho land surveyor with 20 years' experience producing that plat.
So having the line go through, for example, on the west side, lots 6, both lots 6 of blocks 1 and 2 on the upper sheet, and then lots 7 on the upper sheet and 6 of the lower sheet, means they're not going through the same lots, so they can't match. So I don't understand how that can functionally be accurate.
I don't have that document in front of me. Perhaps
Okay.
we could pull it up on the screen, but
Yeah, we could do that.
Are you going to join Zoom?
I need to see.
And then he'll need you to assign him as a presenter so he can share his screen.
Bear with me, please, as I log into Zoom. Dylan, could you make me a panelist, please? Thank you. It looks like you need to turn on sharing for me. There we go. So, Dan, I'm going to try to zoom in so I can explain what I'm referring to. So if you see here, on sheet 3, we have in blocks 2 and 1, lot 7. So if we go up sheet, we'll be on lot 6. But then if we move up to sheet 2, you're in lot 6, and the match line then is on lot 7. So you actually have a match line that's cutting across the middle of lot 6 on the one sheet and lots 7 on the other sheet.
I don't think technically that's a match line. It's not called out as a match line. What you're seeing is an overlap in viewports is all you're seeing.
Okay, so
It's not identified as a match
No
line.
longer referenced as a match line. Okay. I see. So you guys just removed the match line reference. That makes sense. So then it's just a continuation. Okay. Thank you for clarifying.
All right, so now we're going into public comment on the limited scope of this hearing. So first, is there anybody in support of the project that wants to give a comment? No supporters. Anybody that is neutral with this project that wants to give a comment? Dave Bowman.
So, yeah, I don't have a dog in this fight, but I'm curious. When I look at the agenda for this, and we've been through this kind of thing before, where the agenda limits what can be spoken about or deliberated on. And this one says clearly, it's just basically a repeat of the first one. And there's no limitation. So I'm wondering how that gets interpreted as being limited. And I was there at the last one and the discussion and everything, but the agenda says what the agenda says. So that's all I have.
Okay. Anyone else neutral? All right, and then opposition to the project. Bridge Crawford?
Reg Crawford, Bonner County. I totally agree with Dave that open meeting laws require that the public be able to understand what is going to be in the meeting. And this just says the hearing. There's no limitations in the scope. The neighbors and I who are opposing this, we met and we were at the last hearing, we listened to the last hearing, and it was unclear what that scope was. And so we waited for the agenda to come out. And when the agenda did not limit the scope, we felt we prepared our comments based on that. And to hear this is disconcerting because in the past, as Dave said, there have been agendas where it clearly states what the talking points can be during a continued hearing. And so I'm disappointed about that. Also, the applicant was allowed to submit documents this last week within the last 4 days. Again, the public hasn't had time to review. They may consider them very minor, but we have a landscape architect who has put in over 100 plans, stormwater plans with the county. And to us, these documents matter. And with the, the base flood elevation, they submitted a letter that we only got to see in the last 5 days that said it had no bearing on the subdivision proposal. But we had an attorney review it and we have a response to that, but we only got to it last night to submit that. And so again, we feel like we're being cut off at the knees right there. And again, this contour map, that was supposed to be submitted as it's Bonner Code 12-642. It's a requirement of the application. It's not a suggestion. It's not a condition. It's a requirement of the application. And so this incomplete application has already been able to go through 2 full hearings. And I don't understand, and this is very concerning because we're working on the subdivision code right now. And everything is going to start, land divisions are going to be in short divisions or long divisions. And if the preliminary plat is merely like a pile of suggestions with no teeth to it, we're looking for long days ahead. I'm just going to continue. We still feel strongly that this property requires the TIS. Sufficient comment has been made by professionals and experts to prove that the original TG&D letter contained errors and that road and bridge threshold should be used rather than the ITD threshold. PhD is returning to the site in the spring, and Mr. Pippin has stated undisturbed conditions are more appropriate. If the applicant is allowed to begin road construction with the design grading and culverts, the actual conditions will be altered. A citizen who's here today, who is a geologist or hydrologist, ran nutrient pathogen tests on the site and found it would significantly degrade the quality of groundwater and surface water. While I understand that this is not determinant for this site, it does show that this would have potential negative health and environmental impacts. Another.
Pause, Reg. You're out of time. Who's your donator? You got 3.
Okay. Another citizen who is a landscape architect who's here today has reviewed the stormwater site plans and has found multiple issues with culverts, swales, impervious surface, and setbacks, all which lead to the conclusion that the subdivision plan as is not feasible. A list of conditions with this preliminary plat is excessive, yet is being pushed forward as a viable plan with the current, I already got to that. This subdivision is a prime example of why there's a problem. In this case, the neighbors are also experts in their proven fields, and the flaws have been found with this density in this area. We're putting the cart before the horse, and it should be reevaluated after the spring. It is not necessarily the responsibility of this board to ensure the applicant can move forward in a timely manner. The health and safety of public should be a higher priority. The applicant has stated they are suggesting these lots could contain ADUs. Again, this would change the requirements for setbacks and septics. And we ask if this does move forward today, which we hope it doesn't, a condition be made that these lots are not eligible for ADUs. It was determined the amount of impervious surfaces will likely cause alterations in the plans. Again, if this moves forward, we ask that a condition be made. None of these lots are eligible for variances on impervious surfaces. Let me make sure I didn't miss anything. The application finally did submit this contour map. It was just posted last week, and it's our understanding that it hasn't been reviewed by Mr. Ferguson with the county. So it hasn't even gotten that far yet. So it's an incomplete application. Thank you.
Thank you. Anyone else in the room wanting to give a comment in opposition? Sorry, he jumped up faster than you.
Sorry.
Please remember to
Richard
state.
McDonald, Sandpoint. By approving this preliminary plat, you are requiring the future homeowners to do a lot of their own due diligence. When they go in for their building location permit, they will find they need a stormwater plan to allow for the extended driveways, which was not included in the engineer's assumed impervious areas to treat. Half the lots flow away from Deerfield Drive and or have cross drainages and culverts, which must not allow development flows to enter without being treated. I have submitted over 100 stormwater plans as a licensed landscape architect. This treatment is usually done with swales, which is considered open water and requires a 100 to 300 foot setback from drain fields. Because 22 of these lots are 209 by 209 feet square, it's square feet. 2 drain fields are required. This is not doable. And the homeowners will also have to absorb the high cost of having to pre-treat their sewer systems. Because the county hasn't reviewed the stormwater and erosion control plan just submitted, and the contours have been added, and because there hasn't been a TIS for the Deerfield approach to a Bonner County road, as Mr. Korn has said is necessary, and because Panhandle Health will be observing runoff and standing water in the spring of 2026, and this preliminary plat approval should be put off until after that, or stop now for resubmittal. If this goes through, then the county will have to provide wider roads and bike paths for the future developments that will surely follow. This development does not reflect the spirit of the comp plan. If approved, you will be setting up the homeowners to fail, and we've seen where that can lead. Thank you.
Thank you. Sir?
My name is John Monks. I'm a Sandpoint and Bonner County resident. I'm a retired hydrogeologist. I've worked on a lot of projects, developments like this, where my role in doing those projects was to do nutrient pathogen evaluations of their on-site wastewater systems. the rules have gotten a little bit laxer on that. Years ago, that would have been a requirement for something like this. It's no longer required. I went ahead and did it. Doesn't matter. The numbers, they're numbers basically. And it's just not a suitable site for that density of on-site septic. It's very low permeability, clays and silts underneath there. That's why the water pools up in there every spring during runoff. I lived right across the road for a number of years and have observed it every spring, so I just don't think the on-site septic works there. And we already have a problem with the whole Syringa Creek watershed in terms of nutrients, in my opinion. We're having this harmful algae bloom, probably as a result of too much nutrients in the water. To put a whole bunch more of them in right there doesn't make sense to me. So I would have to say no on this one. Thank you.
Thank you. Anyone else in the room?
Hello, my name is Kim Call, and my husband Travis and I live directly down gradient of the Deerfield development. I know, first of all, that you were going to limit comments here. However, all was noted, there was a bunch of submissions just recently, and so I'm going to make comments on those submissions because they were just recently made, and any new information was my understanding about what the restriction was, and that is all new information. I would like to firmly reiterate that it is vitally important for us, meaning the public neighbors, to be able to comment and review on these very important studies and plans related to the Deerfield development, that they're going to affect our future health, safety, and well-being, not to mention our property values. My main concerns are with the following: the septic systems. With the lot densities that are proposed here and the numerous natural drainages that exist, these need to be highly scrutinized and carefully studied. Drainage and stormwater. We have to be able to, as the public, to be able to review and comment on these plans because stormwater flows directly from Deerfield across to my property. I'm the neighboring parcel through 3 distinct large drainages. If the stormwater management plan is not designed and correctly done, damage and can adversely affect my parcel and its value in the future. Despite being granted a variance from the fire department, the impact is of huge concern for my husband and I, especially since we have already experienced fire damage to our property because of this development. It is if the preliminary plat is issued and allows studies and plans related to these issues to be conducted and finalized. Number one, if you do that, it allows it to be done outside the public hearing process. So we can't comment any further on that, though these are vitally important studies that need to be scrutinized. And secondly, our only guarantee to view and obtain copies of these studies is through public record requests. I went into the planning and they told me that they don't have to put these online in the file. If I want updated ones, I've got to go there, on a weekly basis and submit a public record request to obtain these? And this is going to affect me and, my health and safety? That just doesn't seem right. Also, there's really no, like I said, I'd like to reiterate, no public way to comment. So please, Bonner County and our Board of Commissioners, that we ask that you be better than this, and you represent the citizens who pay their taxes and have elected you to protect our health, safety, and property rights. Thank you very much.
Thank you. Anyone else in the room? All right, no more in the room. We'll go online to Anna Trentdew.
Yes, hello. Can you see me and hear me?
We can see your name and we can hear you.
Okay, great.
And state whether you're a Bonner County resident, please.
I am not a Bonner County resident. I'm an attorney who's practiced land use law in Idaho for about 20 years, and I represent Kim and Travis Call. If you look at the changes to the revised plat that was submitted, you will see that your board was finally allowed to see the topographic lines that really show you how steep this terrain is and how the drainages really do empty onto my client's abutting property. Now, your own rules in Bonner County, your code, section 12643B3, preliminary plat procedure. It says that this board can continue the public hearing on the preliminary plat pending the receipt of additional information. Well, you have received new information. You have received a geotechnical report. You have received road, storm, and grading plans. You've received the revised plat that's been discussed briefly. You've received stormwater management and erosion control plans and a memo from the applicant. Your own ordinances, 12643B3, allows you to continue this hearing to take public comment on these new submittals. And I would highly recommend that you do this. If you don't, what happens is your process is set up so that there will not be any opportunity for public comment on these studies, and that is a due process problem. I've been practicing land use law for 20 years. Now, no judge is going to come after Bonner County and say, you should not have continued a hearing to take more comment on these studies that hadn't been presented earlier. That's just not the way it's going to work. That's considered good process. That's your board ensuring that you have a well-developed record upon which to base your decisions. In fact, if you don't take comment on these studies, you won't be able to make a finding that your own standards for review for applications for preliminary plat have been satisfied. If you don't look at these studies and take comment, how can your board truly determine that the Deerfield site is physically suitable for the proposed development? That's criteria B. What facts can you point to confirm that the design of Deerfield will not adversely impact Bonner County's natural resources? That's criteria C. If you don't continue the hearing and take comment on these newly submitted materials, you will not be able to make findings of fact that you have met your own criteria. Again, I want to incorporate by reference all of the due process objections that I added in my 2 emails that I have submitted to the county in the last few days. And I would ask you to please continue the hearing to take comment. That's all. That concludes my comment. Thank you.
Thank you. John Plant?
Jonna Plant Sagal. I'm only commenting as a taxpayer, and I hear that the open meeting law publication was not limited. So I really would like it to be open to all that needs questions from Asia or whatever. I don't want another lawsuit from either side, and I appreciate you listening to all of it. Thank you.
Thank you. Is there anyone else online that I can't see? All right, anyone else with their hand up? Okay.
Was there a basket to submit one-page comments?
A basket?
Well, you used to be able to put in one-page comments, or is that not acceptable?
You can, so the question, so I was going to ask a couple of technical questions in terms of typically, so I didn't ask Reg, are you going to hand in your note? So was there a cutoff time for submission of new information that was given? Was there a specific date that was given? And let me technically say we're closing public comment now because there's no more public comment, but was there a cutoff time and date for submission of information related to the questions that were asked by commissioners at the prior hearing? No, Director Gabel said there wasn't a cutoff period. So then I think it's reasonable that those who wrote something can submit it then, since there was no cutoff time.
So typically, our notice of public hearings contain some kind of 7-day, submit something in writing 7 days prior to the hearing. Because this was continued, we didn't have an additional notice, so there was no limitation as to when a document or comment would be submitted.
So if someone wants to submit something, name it, date it, and hand it to the clerk on this side. Okay. All right, so we're going to go into rebuttal by the applicant. Does the applicant have something that they want to say after hearing public comment? Yeah.
Hello again, Dan Taddick with HMH Engineering. In response to a couple of the comments, contours were included with the original submittal. They were not included on the original plat submittal, but they were included with the original submittal. As far as the concerns regarding septic, approval of the preliminary plat does not grant the developer the right to sell property. What it does is allows him to move forward and construct sufficient improvements to establish the new drainage corridors that were reviewed and approved by Bonner County staff regarding the stormwater report, and allows Panhandle Health to do their job and evaluate for setbacks in the spring. As they indicated at the last meeting, they prefer to see the constructed improvements, evaluate the constructed improvements rather than the virgin site when they're doing their monitoring to determine setbacks. So if it so happens that some properties are constrained in the future, well, that the plan has to change at that point in time. But this is the process. This is how the process works. We don't know that until they have an opportunity to observe in the spring, and they don't really have an opportunity to observe conditions in the spring until the improvements are roadways in, drainages are cut in, that sort of thing. So it's perhaps an imperfect process, but that is the process.
Is that all? All right, thank you, sir. All right, at this time, we'll close and go into deliberation with the board.
Before you do, I'd like to make a comment. Dan Rodriguez on behalf of the applicants. Just to clarify one thing that Ms. Trinity was talking about, and I would defer to her greater experience, but I've read the code as well, particularly the section that she referenced, sub B, sub 3 of 643. And what that says is the board may continue the public hearing on the preliminary plat pending changes made in the application, which this board did, and which changes were made and submitted. And there's nothing here to indicate that there should be a continuation beyond that submission to allow for additional public comment. That was the scope of this hearing today. The submissions have been made and were available. I think the court has met all of its duties under the code. I disagree that any court down the road is going to be chastising this board for not fulfilling its duties under this code. So again, deferring to her greater experience, but the code is clear that you can continue this to allow changes in the plat. You did so. We're here to consider those changes, and now the board is free to deliberate on the issues.
Okay.
Thank you.
Anything further from the applicant side? All right, now we'll go ahead and close into deliberation. I have a question of clarification to Bill Wilson. So 12643 subsection B, we're skipping a word. It says the zoning commission. And so my question is, because they have added additional information, should this be actually remanded to the zoning commission for a review, for a recommendation that then gets submitted back to the Board of Commissioners to make a decision? And the reason I say that is they're both referencing this additional, go ahead and put it back, but it says the zoning commission shall hold the public hearing on the application for preliminary plat in accord with the procedure set forth in subchapter 2.6 of this title. Commission shall consider the application for preliminary plat and any comments received and facts on the record and may, and then the subsection that council references is continue the public hearing on the preliminary plat pending changes to be made in the application, the subdivision design, or the receipt of the additional information. So when it says zoning commission, is this directing that the Board of Commissioners should have, when they wanted the application, when they received the change to the application, should it have actually been remanded to the zoning commission for a recommendation in totality? Because when you look at this particular file, there's a lot of changes here. And so as the changes occur, was each one fully reviewed by the zoning commission for their recommendation that comes to the Board of Commissioners for a complete recommendation with each iteration of the changes? Because I see that the applicant has provided the information as requested from the hearing with the Board of Commissioners. But when you're talking about both attorneys are referencing a code, it's actually remanding, it's the zoning commission that code is talking about. It's not Board of Commissioners. So what is your opinion on that, which both sides, and I'm saying she's on a side because she's in opposition for a person that's, doesn't want it to move forward?
Well, a couple of caveats. I don't have that language in front of me, number one. And number two, I do believe it's been the board's practice for as long as I've been here to allow for additional information without being remanded to the zoning commission. Jake, if there's
Wait,
code
before
here
you-
that I'm not considering, I think that
I
has
wanted to
always been.
stick on this lane for a second, only because this has a lot of people having questions on it.
Right.
And I read the code as it specifically is written here, and it says zoning commission. And I do know that there are times when we say, hey, bring me additional information. This, when you look at the number of changes here, there are quite a bit of changes. And if I'm objective, without saying which decision you go, if I don't get information until last week on something that's germane to the preliminary plat, and I am a person in opposition, do I really get an opportunity to digest? And in part, I am thinking on behalf of the county, because my job is to be, what's the best based on the rules? Is there an argument for that when you look at that code from a legal perspective, in your opinion? Not saying this is how we've always done it, but an interpretation of the law is what I'm asking for.
Sure. If we could have that pulled up
Actually,
so we can take a look
yeah,
at that.
we're, as a point of clarification.
Right. I don't want to.
Regardless of what references were made, I think we should be looking at subsection F, because that refers to the board.
Yeah, the board shall hold, the board shall hold. Which subsection did you have?
12643B,
Zoning commission shall, right?
and then number 3, which is what Trentadue commented on.
So I think. and we're
So,
just looking at-
because the argument that she was making was that this file has received additional information.
Right.
And so that when it says commission, and so I'm referencing what the person said, not what I'm
Right.
trying to address an issue that someone else brought forward. And so she's arguing that the application for the preliminary plat had the opportunity to go back before. This has had a lot of changes. Would it have been more reasonable and appropriate from an interpretation, from a legal view, that this go back to the zoning commission given the changes?
Let's
Based
look at-
on what she has put forward, I'm asking for clarification.
Right, so she's looking at a portion that discusses the zoning commission. And please forgive me as we just do this on the fly, right? I hope we can give you guys the best answer that possible. But then as you go down the statute or the ordinance, we go to subsection E. That goes to the board, right? Because that doesn't start with the zoning commission. That one says the board shall hold the public hearing on the application for preliminary plat in accord with the procedures set forth in subsection or subchapter 2.6. The board shall consider the facts of the application, any comments received and the facts on the record, et cetera, et cetera. And then subsection F, the board.
Oh, wait, I can't let you skip past that.
Okay,
Because
we'll read
when-
it all. We'll read it all.
Well, no, because when it says board and it's referencing 2.6, it's still referencing zoning commission. And so that's what I'm asking for clarification on, because it's talking specifically about which board in this section. And that's what I'm asking for a clarification on.
It says there's.
It says
it's
hearing
the zoning
conducted by the
commission.
zoning commission.
The zoning commission is identified higher in the ordinance.
But it's also in
But
E and you
the
skip
board-
that.
I read this to mean the zoning commission, when it's identified as such, is that. When the board is identified, it's speaking to the Board of County Commissioners.
So in subsection E, the
Right.
part that didn't come out was testimony and evidence received at the public hearing conducted by the zoning commission. And so that pushes, in my opinion, a need for me to review 12643B subsection 3 of the zoning commission would not have reviewed the information that we're talking about because it was not remanded to them when we received additional information.
So if you go down to subsection F that follows that, it says the board may approve the application for preliminary plat as presented, approve the application as modified in any particular, which seems like any particular way, I think. There might probably there's probably a missing word there. And number 3, continue the public hearing on the preliminary plat pending changes to be made in the application, the subdivision design, or the receipt of additional information, or deny the plat or the application for plat. So perhaps having now looked at the ordinance together, it actually looks like subsection F is the one that, under subsection F3, that was the board's authority to continue the public hearing on the preliminary plat pending changes to be made in the application, the subdivision design, or the receipt of additional information. I think that's what we did. So maybe there's just different portions of this ordinance that have been highlighted by the different attorneys here, and I certainly, I have no reason to question Anna's expertise. It sounds like she's got more experience here than I do. But if we do look at that subsection F3, that seems to be, and assuming that the word board means you guys, which I think is a fair assumption.
Under definitions 12802, Board of County Commissioners, and highlights as board, elected local legislative bodies. So in our definition section, when it governs how we evaluate these terms, board refers to the Board of County Commissioners.
So I don't not understand that. I'm still asking about the section above that talks about the zoning commission reviewing the changes to the application. And my question is, given the changes that were made and the comment made by the council online about the public not being able to comment, would it have been appropriate for the Board of County Commissioners to remand it to the zoning commission given the changes to the application that were made, is what I'm asking?
I think no. I think no, because of subsection F3, which specifically says that the board may continue the public hearing on the preliminary plat pending changes to be made in the application, the subdivision design, or the receipt of additional information. So that happened.
So I think that
that's-
this is a difference of legalese, because I understand that it gives you the ability to make the decision to accept, to deny, or to change. I'm not understanding that. I'm asking, given the number of changes and what was asked, would it be appropriate to have remanded it to allow for the public comment on the changes that were requested? So it's not, I can see clearly what you're saying, but when you look at the part above it, that's what my question is, because that is in part what somebody on this other side of the table who has representation is arguing was a more reasonable approach. And as we're making a decision that pits the county in front of, either way, somebody's not going to be happy. It doesn't, that's clearly what's going to happen here. I'm asking so that as I adjudicate the decision of this file, that I'm considering, would that have been a better path to address a potential piece of litigation that somebody's attorney is bringing forward as an issue? And what I'm extrapolating from you is because you can, it was okay.
Because there's clear authority to do that, then I would say you just follow this, you follow the language of that ordinance. Yes. I don't know, Jake looks like he's jumping at the.
No, that's
I was only asking a legal opinion. That's all that I asked. No, thank you. I was only asking counsel for the county. We're gonna wait for Commissioner Korn to see if, did he send you a message?
I guess that's why we've always done it that way. Sometimes it works. I don't, like,
I hate that.
sometimes it doesn't, sometimes it does.
Always done it that way is not a good legal opinion.
I got it.
All right. That was a question that I wanted to ask based on that. So, does the board want to go top to bottom on the form? What's the appetite here? Commissioner
Sure.
Korn?
Yep.
All right.
Seems to be the best.
Yeah, we can work that way. I guess if you guys would prefer to do it that way, then I'll address my perspective on the letter we received from the applicant's engineer.
I think we
As part of
can,
that.
do you want to just have a conversation first and then go top to bottom? Because I think that's not unreasonable to do.
Whichever you guys prefer is fine.
Commissioner Korn, do you have an issue with him discussing the applicant's letter?
I don't have an issue with that.
All right, Commissioner Domke, to you.
I'm Appreciate the perspective provided in writing by the applicant's engineer, HMH. I do have a different perspective, though, on what's been presented. And the reason is, there's a, part of the opening statement says that the Bonner County Revised Code requires compliance with federal determinations before building permits are issued, not before preliminary plat approval. And while that statement, I believe, is true, I think what's missing is that we still have Bonner County Revised Code 14-501L, which requires, quote, "all subdivision proposals and other development proposals shall be consistent with the need to minimize flood damage and determined to be reasonably safe from flooding," end quote. So my question is, how can the board determine that that proposed subdivision is safe from flooding without the base flood elevations having been confirmed? And part of the concern for me in looking at the updated information is that when I look at the stormwater drawings that include the stormwater pond and the stormwater tract, we have a bottom elevation in the stormwater pond of 2086, and we have a top of pond, or essentially the berm at the rim of the pond, that is designed at 2090. And this letter indicates that based on the current highest calculated base flood elevation in the proposed project vicinity, which they say is located upstream, but that's at 2092.2 feet, which is higher in elevation than the top of pond as designed and proposed at this time. And it's a little hard to tell with the information that's submitted, but it also appears that based on the current FEMA map with the zone AE, the 100-year boundary, that the proposed stormwater basin may overlap with that. And so without having that information, I'm not confident that the stormwater pond is functionally capable of working within these conditions, and that we can meet the requirements of BCRC 14-501L. So I still have this, my concern and request for information that came from the last hearing is unchanged for me. I still feel that I'm missing that information to make an informed decision in compliance with this section of the county code.
I had difficulty with the same, I had a lot of difficulty surrounding the water and septic stormwater issue on the plan itself. And hearing applicants comment about the way that you know that is once we get to spring and PhD can go out, and it's, I think what it comes down to is there needs to be a greater investment, which there is an element of risk of whether or not you could prove it, but there needs to be more put into it to show that this would be met. And then some of it's outside of the county control. And my concern is I had a problem with 1214. I have a problem with being able to prove that is addressed in this plan, with a concern having gone through what this file, the concerns are. It does surround this issue that I didn't feel that I could make a solid answer on in the file as presented, and going through that letter and then reviewing and re-reviewing 1214 with respect to the letter that was submitted by the applicant. Commissioner Korn?
I do not share your opinion.
Just mine, he said something too.
I do not share either of your opinions.
That was clear.
Thank you for clarifying
Just
that.
want to be fair and equitable.
Yeah, preliminary plat, very beginning, things change, but they got to be able to start breaking ground to figure out exactly what's going on. Wastewater management changes depending on what changes down the road. I've never heard of delaying preliminary plats till spring. If that was the case, we'd be doing everybody in the spring, because spring is when the water comes, no matter where we are in this county. So I don't see that as a concern.
I think this one was different for me on a lot of things because it's a known floodplain area with water issues. And I think that that is in part what a lot of people, when you read through the comments and the file, because there's a lot of mitigation efforts on the part of the applicant as well, but there's actual recognition that this is an issue there. And I think that that's why they requested the LOMC LDMR. And unfortunately, federal government moves slowly, which is part of the problem. But to ask the county to leapfrog over that, I can't confirm that that doesn't create a problem. I can't answer one of the questions that's being asked with respect to this file because of the unique conditions on this particular area of development. And I think that it's unfortunate, but that's part of what land development is I feel like in a lot of ways, this one is asking us to trust that we'll mitigate it as we identify the issues moving forward, but it requires me to agree that it's mitigated before that's put in place. Because I can't check that box off. I can't.
I mean, from my perspective, I need to have a level of confidence that we can comply with the code to deal with the safety issue of the flood zone. Going back to the comment about PhD and septic, that was discussed a little bit at the prior hearing, and I know my initial position on that was questioning whether we should wait until spring. It's my recollection and understanding from what Mr. Pepin from PhD presented during that hearing, however, that the PhD would have the preference of having the at least the basis of the stormwater system in place so that they're testing ground that would be closer to the condition in which it would actually have storm systems developed, was the way I interpreted his feedback, which I can understand. And there is obviously risk, which is appropriate for a developer to take on if they pursue a project that has unknowns, that they may have to increase parcel sizes, reduce total number of, lot sizes, and increase those and reduce the total number of lots within a subdivision if the ultimate available permitting approvals don't allow for what they're proposing. I can accept that aspect of it, but I am still concerned that I personally can't sign off on what we're required with my reading of the code right now, with the lack of the information coming back from FEMA.
So your guys' one of your main problems is the floodplain?
That's my concern right now, is I don't see.
Can we throw that map up on the screen so we could take a look at that, or whoever's
Code section or what?
the map of where the floodplain it was compared to where the property is?
Alex, do you have your laptop and you want to can share? I'm not in the Zoom session.
I think you'd actually want to pull up the preliminary plat, because that has more definition than the GIS, or you could show both.
Jason Johnson, Bonner County Planning. You should probably just actually pull up the GIS because that's going to be how the county makes decisions.
Does that, Mr. Johnson, does that mean that we're supposed to disregard the Zone AE 100-year boundary currently shown on the preliminary plat?
In my opinion, our code is in error in requiring that floodplains be shown on plats. Floodplains are not surveyable boundaries. They shouldn't be shown on plats. Also, we don't control the floodplain. The floodplain is federal and it's controlled by the federal government through FEMA. The floodplain is where it says it is. If FEMA changes where the floodplain is and you have a plat that shows the floodplain in a different place, The county will be expected by the state floodplain coordinator and by FEMA to enforce the map that FEMA publishes, not the floodplain that's on the map. So I think for two reasons. One, it's not surveyable, and two, it's not even really the power to enforce for floodplain comes from firms. Flood insurance rate maps as published by FEMA. We do not get to usurp FEMA's authority by writing stuff on a plat and then stamping it. So in my opinion, they shouldn't be there. The code requires them. We put them on to the best of our ability.
So for clarification and so that I can better understand your concerns, can you try and explain to me on that map what your concerns are?
Yeah, Commissioner Corn. So if you look at the southern extent of that parcel, you can see the dark blue area is the flood map. And the two lots that are shown on the proposed preliminary plat that create that southern jog rectangle, the larger western lot, lot 10, comprises a little bit more than half, or the left side of that rectangle, where the current flood map shows it going through. And then the right side, or the east side, where it's approximately shown as being half of that proposed lot, is the stormwater tract that's been proposed, where they want to deal with the majority of the stormwater mitigation for the subdivision. And then in their submission, they have a stormwater pond shown on that parcel. And there's a lot of, there are very steep slopes there. There's a lot going on with being able to make that stormwater mitigation system work in that area. And the actual elevations of the flood zone, assuming there is a flood zone there, could either make the stormwater system much easier to install or very difficult to install, and could impact the ability. And then we have this lot 10 again on the west side, which is proposed to be a lot for residential development as compared to specifically for stormwater use. And so for me, in my perspective, when I read the requirement of Bonner County Revised Code 14-501L, when it says all subdivision proposals and other development proposals shall be consistent with the need to minimize flood damage and determined to be reasonably safe from flooding. I don't know how I can say that I can affirm that that's the case without knowing that information, because of the level of potential development that would want to happen on those two lots. That's the concern that I have, and that's why I would like to have that data confirmed by FEMA before making a decision on this proposal.
So again, Jason Johnson, Bonner County Planning.
Can I pause you?
Yeah.
So Commissioner Domke needs to ask a question because we're in deliberation by the board. So do you want clarification from?
I have some clarification on that.
If Commissioner Domke wants that, we're in deliberation.
I'm happy to have staff's feedback on that.
Jason Johnson, Bonner County Planning. I'm also a certified floodplain manager with the county. I've been doing the floodplain here for about 10 years. Reasonably safe from flooding is I guess a term of art from FEMA. That's where that language comes from. All of our flood code really is a local implementation of Code of Federal Regulations, Title 44, chapters 59 through 61 mostly, some 62 in there. Our flood code comes to us in a model form from the Idaho State Floodplain Coordinator, who creates the model off of the federal code and then tells us what our code looks like. And then we make maybe a few minor tweaks. We have a few minor local adjustments. We send it back for approval. And if they say, okay, then that's where our flood code comes from. We don't actually get at the county level very much wiggle room on that. Reasonably safe from flooding is determined by the flood code. It's everything else that's in the flood code. If something complies with the local code, which is ultimately a local implementation of federal law, federal flood code, then FEMA considers it to be reasonably safe from flooding. FEMA is always very clear that anywhere it rains, it can flood. Anywhere from 1/4 to 1/3 of all floods in a year happen outside the mapped floodplain. FEMA is very straightforward about that, but They're not looking to make places immune from flooding. They're just looking for reasonably safe from flooding. That's defined by the flood code. In this particular case, it would be BCRC 14501, the totality of that. There's quite a few requirements in there that would apply to this project. Should they fail to get completely removed from the floodplain, they would be, the applicants, required to get a floodplain development permit under Title 14 for this subdivision, demonstrating with stamped engineer's drawings and certifications that every aspect of the subdivision development, and that's development of the subdivision, not development of the homes, but development of all the infrastructure for the subdivision, is compliant with our flood code. And if they comply with our flood code, then we would consider it, and FEMA would consider it, reasonably safe from flooding at that point.
Thank you.
So I have another question for planning. So being this is a preliminary plat that we're being asked to accept or deny, if we accept it and it is found at a later time, say spring or whenever FEMA gets around to answering some of these questions, that those two lots that you're referring to cannot be built in, or they're going to require special methods of being built on, or it gets turned into a green space or whatever, is the applicant allowed to change their design and take that lot out of a building lot? By accepting this preliminary plat, is it set in concrete that they can't change any of their plans?
They always allow in planning for you to reduce, it's the increase. I think the question.
I would just like to hear.
It's a board, it's the board is accepting that. So floodplain manager, who are you asking, which one?
I asked the planning staff.
Yeah, plats change all the time between preliminary and final. That's one of the points. Once engineering starts happening, you might learn new things. Things might change. Commissioner Williams is right. Reduction is generally a lot simpler to deal with than an increase. If they wanted to increase, they'd probably be required to do a modification in most cases. But even through a modification, technically, yeah, you could still change it. Reducing it, would we require a modification? I think that's decided a lot on a case-by-case basis. Usually a reduction in impact doesn't always require modifications. I mean, generally, the purpose of a subdivision is to make money, so people don't usually want to reduce anything. So if they're reducing, we kind of presume that they're doing it because there's an engineering necessity to do it. But yeah, that's the point of the preliminary and final. We don't know what the final is going to look like.
Thank you. So that's what I'm just trying to make sure the difference is in preliminary and final, and I'm trying to address your concern by if we were to go ahead and accept this preliminary plat, that doesn't lock us or them into building in a floodplain if that is later determined to be one, or to the builder or the developer can figure out different ways to build in that floodplain that are legal. I don't know, because I'm not a floodplain expert.
Sure.
I'm just a commissioner.
I appreciate what you're wanting to clarify, and I am understanding of that. The issue for me is, my opinion is we, with the preliminary plat, have to look at what's been proposed and determine if we think it complies and if we think, if it's a reasonable proposal. Because once we approve that, right, then all the processes go beyond what this board oversees. And so I think our responsibility is to say, is what's being proposed reasonable? I understand the adjustments typically do happen through the process, but if what's being proposed is not something that I understand to be reasonable based on the information that we have before us, I have to make my decision on that. Ultimately, otherwise, somebody could just, the process would be, here's a blank piece of paper, I just want approval, and I'll figure it out as I go. And we have to base our initial decision on some reasonable amount of detail. And so that's why I'm, again, trying to understand, do I believe that we can find that this complies with the requirements of the code and the comp plan? And on the one hand, absolutely, in my opinion, the comp plan, right, this is a transition designated area of land use. It was then zoned suburban. It's where development was intended from a county planning perspective to occur at a higher density than the rural areas of the county that are further away from the urban interfaces. And I can appreciate that intent, and I don't necessarily have an overall concern that this property couldn't be reasonably developed at the current number of parcels and sizes, or lots and sizes. I'm not confident, but again, some of that would happen through the process, such as with PhD. But for me, I still don't have enough information to feel confident to say that what's happening on the south end of the property is viable and safe as far as proposed right now. So that's the piece that I'm struggling with. There's some other aspects that could get discussed in more detail that have been brought up through public comment. But I just, as a fundamental aspect, if we just simply said it's preliminary and it's going to change, then we wouldn't need to look at any details.
I have a similar comment. I think that that's part of what community has a concern that we address from everybody's developers and the neighborhoods that development's going into, is this idea that it can just always change, because there is then there needs to be a foundation by which we're building the development off of, that we're reasonably considering the things that the board is supposed to consider with approval. And if the argument is, we'll just approve it and then they'll mitigate all of the issues as they move forward, then you don't need a board to review any plat ever. You just say, here's my land, I'm going to build. And so at what point you actually serve to devalue the whole preliminary plat process if you don't require a preliminary plat, which gives the reasonable idea of the direction of the developer, with reasonable recognition that as a developer starts digging on their plot, something might come up that requires an adjustment, but it shouldn't be that the whole picture is shifting, because it's very possible that the shift can be that in that stormwater area, that those two lots aren't something that you can build on. But the board doesn't have the objective information to say anything about that. All I know is they want to build on that. And so do I approve it and say, well, if they're not allowed to build, then for me, it's, well, what am I approving? I'm not approving anything. They're just going to change it based on the conditions. And so I think there's a need to have a foundation. And on this project, I accept, which I know a lot of people in the area, no, it's a lot of homes. A lot of people have commented on, it's a lot of homes going in, but at the same time, that's what this was zoned for. It was intended to increase the development there. My issue is very similar to what Commissioner Domke is talking about, is this the right number of homes to put on that based on what information we currently have and what's available to us? And in large part, some of this information is just not available at this time. And really what I feel like this question is, will you approve it? And then we'll work it out as we get the information along the way. And that is not, in my opinion, responsible development to say we're just going to rely on the process of changing when there's a flashing stop sign of caution on this particular development for the reasons identified in this file. And the reliance is just, well, planning can work through it as it comes up once you approve it. I can't get past the same thing that Commissioner Domke is talking about on this, while equally saying to the community that doesn't like the idea of 24 homes going in, saying this is transition spot. This is where it was identified in the county for that increase. The mitigation factor is what Commissioner Domke is highlighting for me, as well as a host of other stuff I wrote that I can't put on this one. I should ask that question before I do all that work, but that's where I am with it. Is in some ways it's, for me, premature request without that verifying information. Anything further, or do we want to go through the list?
So the difficult piece for me is I feel like I'm at the same position I was in the initial hearing, which is I don't want to go through and make a vote to deny the application at this time due to a lack of information. I'd I'd rather have the additional information to make a well-informed decision. But my request for the missing data from FEMA hasn't come through yet, unfortunately, but I still don't feel like I can move forward without it. So I don't want to penalize the applicant by denying the application because of that, but I also don't feel that I have enough information to make a decision today.
Couldn't you say that, remand it to the zoning commission with the documentation from FEMA as part of the application adjustment? Because I can't determine that aspect of it, so that would be, because I can see that, or do you say, because having heard the comment just made, make a decision and let them litigate the issue? Yeah.
This is a tough, maybe a difficult procedural question, because I understand the desire for additional information, but we also, I think that the applicants may choose or may desire an up or down answer. Part of this also hinges on timing, and we're dealing with the federal government, so we have no control over that. One additional step that remains in the process, regardless of the decision you make today, whether it's yes or no, is that there is a reconsideration period. We would be kind of painting ourselves into that corner. If, we have 60 days after the final decision is mailed to the parties in interest for them to seek reconsideration and for us to then make a decision on that. It sounds like the FEMA representative suggested that it would be coming quickly, but that didn't happen. Go figure. I also don't like to kick the can down the road to continue, because they might prefer, if they don't like that answer, would just prefer to have a denial that they can then litigate.
Well, let me ask you this, because on the comment about FEMA moves slowly, government does move slowly, and they have a review process, and all sides need to know that this issue has been reviewed by them. And so I understand that you submit it and you didn't get an answer in the week that you got the request for clarification, but in the world of government, that's fast to expect that they give you an answer in a week's time. And so I don't want to say, because the federal government hasn't given a weak response, that let's just move forward in hopes that they give it, versus saying,
I didn't mean to move forward. If you're trying to decide whether or not to continue this hearing again, or actually just what it sounds like from Commissioner Donkey, move to deny because you lack the requisite information necessary to feel comfortable with the decision, right?
Correct.
If
Those
you
are the two
deny,
options.
if you move to deny and you have a majority vote on the board, at least that gives the applicants the ability to appeal that decision. We have recently remanded at least one file that I can recall back to the zoning commission, but for purposes of appeal, that is a denial, right? Because we haven't formally approved that project. So even if we chose to go that way, if the appellants, or if the applicants, deem that a denial and then move to appeal that decision, I think that would be within their rights to do so. When we remanded the last time, it was because it made sense for all the parties to do so, and it was procedurally agreeable to everybody. I just want you to know, I think even if the decision to remand can be perceived as a denial because we're not granting that. And so if they just want the right to appeal, then that might be something you have to consider.
okay. Thoughts about Mr. Wilson's legal opinion?
I'd be more than comfortable asking the applicant what their preference is. Like I said, I'm not intending to cause them undue harm. I just am personally uncomfortable with the lack of information and render a decision.
Okay, so does the applicant want to give a response on the issue brought forward? You're going to draw straws on who's going to answer. No, you're good. It's like a Jeopardy question back there.
Understandable, it might take a few minutes.
Just, I guess.
Can you?
Dan Tadek, HMH Engineering. As was pointed out in the memo, I guess, just for clarity, the home sites are 26 to 30 feet above, what we're talking about for base flood elevation of Surinka Creek. Figure that is an important point to point out here. But would the board consider a vote contingent upon the FEMA data supporting the application? So a yes pending a FEMA adjudication and agreement with our base flood elevation?
Don't know how to make decisions on the worksheet on each applicable code without knowing the answer from FEMA.
That, I think that our process has us going through the code itself. And I think that question impacts how we would answer on our worksheet that we have created. So I think that is the problem. So from your view, do you guys have a preference of you want a decision, a yes or no decision? Do you want a remand? What is your preference on that?
So before they answer that, I do think that the board.
One more question
I think-
is you could say that you would want to continue if you think that, and if you gave yourselves 30 days, if you thought that FEMA would give you an answer in the next 30 days, and then it was just coming back in 30 days and notifying the board, and then we could schedule it as a deliberation hearing pending receipt of a response from FEMA and giving you 30 days for that.
One additional comment for the board's consideration here. So Jake and I are just looking at the code here as it relates to the requirement or the information that Commissioner Donkey and Commissioner Williams are still asking for. And when we look at, it's back to 14-503, subsection 3. All subdivisions, manufactured home parks, and other development proposals shall provide base flood elevation data if development is greater than 5 acres, or as more than 50 lots manufactured home sites / manufactured home sites. Such base flood elevation data shall be adopted by reference in accordance with BCRC 14-302 and utilized in implementing this title. And then here's the relevant portion. The applicant / developer shall submit an application for a conditional letter of map revision, or a CLOMR, prior to preliminary plat approval, and have obtained a letter of map revision prior to any building permits for structures being issued. So we have to make some sense of that ordinance. That seems to suggest that submitting the CLOMR now at the preliminary plat stage is a requirement, and they did comply with that. We obligated them to do that. But then the following portion of the sentence says that, and have obtained a letter of map revision, an approved letter of map revision, prior to any building permits for structures being issued, which implies that the code requires the conditional letter at the preliminary stage and only requires that they receive the actual LOMR later. So
I
just
see
wanna
that, and that
put
was,
up for the
that was
board's
outlined
consideration.
right in HMH's letter, but is it not correct that if you look at 14-501L, that from a hierarchy perspective, right, that we still have to comply with 14-501L?
That one says down a little bit.
I think that
Because then isn't 503 essentially subservient to 501? It's a
think-
more detailed attempt at, so I think we actually have conflicting language between 501 and 503, where 501 is more restrictive than 503. But I don't know that we can ignore and abandon 501L, which is the issue that I have that I'm trying to address.
Well,
I think that it can come across, and I want to be mindful of this. I don't want it to look like the county's looking for a way, we're looking for a way to move forward with information that's been requested, not how to come up with how to say yes, how to say no. There's a piece of information that has been identified as requested by the board to make a decision. And so I looked at what you guys looked at. I looked at the 14. There is some issue there from the board perspective. What the board has asked is, what are the options moving forward, asking the applicant, given that you don't have the answer from FEMA, and it's not within our control. I'm hesitant on how do I push forward past that aspect when that's the question that two commissioners have put forward of, we'd like to have that answer, and not having that answer to say, because if I try to think of on both of the sides, because someone is always unhappy. If I'm on this side of the room, they're going to say, well, it sounds like the county's just trying to figure out how to make this work on the fly. And I don't think that's what you guys are trying to do, but the board has asked a question about information we don't have. If the question is to the applicant, what is your preference? Are you looking for a decision? Would 30 days, do you think, allow you guys to put pressure on FEMA to give an answer, to bring forward the requested information that hasn't been received?
Before we get to that point, if that's the interpretation of the proceeding code section that you have just decided to make, you guys get deference when you interpret your own code, that's fine. For defensibility purposes, I mean, the section that I raised is probably going to be front and center if this claim is subject to litigation. So when we deliberate, it's in your best interest to articulate why you chose to go in a certain direction in spite of or against that language if you find that another interpretation is more convincing. So to your question, we need to determine that even in spite of that language, the board is still permitted to deny the application, although, in spite of that language. And then once you've made that determination, then move to the question of, we plan to deny, so are there other options that we would like to work with you on? Does that make
Or
sense?
if he had just picked an option that I gave, then we wouldn't have that as an issue, though. I mean, because that's what the question was to them of, potentially they could have just said, well, let's continue for 30 days and see if we get the FEMA letter, because they're not doing test
Fine,
holes.
too.
And then that addresses the concern. And I'm trying to be mindful of everybody involved in this particular case. And because you're presenting an argument to move forward with the application, which I understand, but arguably as the board deliberates, the question going to them gets interrupted, and then it looks like we're not just soliciting an answer from the applicant. And I'm trying to be respectful of everybody in this hearing who has an interest in what we're doing. And part of what the question was you brought forward that you think that they're looking for an answer. We're asking them, would 30 days potentially help secure the information? Because 1 week didn't work, 1 week was very short. So you could continue for 30 days, they're not.
I agree that if they agree to that, that's in our best interest, because we would want to see the information, we want to have that vote. I just don't want to presume that is what they want. So I'm happy to.
I'm not presuming, I posed the question to them.
And then move forward, just keep that in mind.
I'm not presuming I posed the question to them. But before we ask, I've asked a question of the applicant, if I could let them answer now, please.
Well, my question kind of supersedes the applicant's answer, because I want point of clarification, because the applicant asked a question that we were not able to answer. I would like to know if the board has the authority to go ahead and approve this preliminary plat on the condition of, or that within the 30 days that we get that information back from FEMA and that it's acceptable. That way we don't have to go through another meeting and all that. So I would like that question that was brought up. Do we have the authority to do that or not?
I've never seen that done before. To reiterate, you're saying approve conditioned on the receipt of certain information from FEMA? Without a time frame. The problem with that is what if they give us an answer that doesn't clearly articulate, whether it satisfies the concerns of the board or not? There's too many variables there that would make me uncomfortable doing a prospective approval subject to additional information. And frankly, if we're going to ask for additional information, if we're trying to be sensitive to the due process interests of everybody involved, I think the neighbors would also, if you guys have your heart set on a FEMA delineation determination, everybody else who lives next to that property also has the right to review that document when it comes in and say whether or not it proves what the board is asking or looking for. So I would say no to that.
Okay.
If the applicant agrees that a continuation is better than a denial and a resubmission or litigation, then that's great. And I think I would recommend that to you guys because it's in the county's best interest to work with them on that. But I do think it would require another hearing. As much as I know nobody loves a million hearings, but trying to be respectful of that due process, we have to afford that to the people that want to come and talk about it.
Okay, thank you. And I keep hearing the board is suggesting this and the board is wanting that, and you guys, I would like to just ask that we clarify that it's not the board asking for this, it's two of the commissioners.
My bad.
I want to clarify that because it's going around a lot, and I want to be clear that I am not asking for this.
So my question,
I can address your question, Mr. Williams. So the question you're asking is, would the applicant prefer to have an up or down decision today, or would the applicant agree to a continuance essentially to see what FEMA is going to bring? So our position is this. We have complied with everything the code requires. I actually have the exact same code section Mr. Wilson just read to you, so I won't read it again. But the reality is that we have submitted the Clomer letter that's required by the code. We've submitted all of the documents required by the code, and we've given you all of the information that you would normally have in order to do preliminary plat approval. I understand the concerns of this board or at least, two of the commissioners about this.
so I'm going to clarify, board is based on the majority, that's why it gets used, so that's part of what's happening
I
here.
just wanted to respect Mr. Korn's position on that. But Mr. Korn's explanation of the situation is actually the correct one. The applicant is stuck between a rock and a hard place because they can't make any of the changes they need to make in order to get final FEMA approval unless the preliminary plat is approved. In other words, your denial today or your resubmission to the zoning commission is simply a delay which will not only cost them 30 days, which, as we all know in this business, time is money, but it will cost them into next spring because they won't be able to complete the road or the mitigation efforts prior to the snow hitting. And then we'd have to wait for the melt. So we're looking at April maybe to get started. So now we've cost the applicant from the original application date in June, almost an entire year before they begin to even see whether we can build on all of these pieces. I think Commissioner Korn is absolutely correct. If it becomes an issue, either from the FEMA report or ongoing engineering decisions, that those two lots can't be built on, or only one of those lots can be built on, or one of those lots has to be heavily modified, so the other one can be built on.
Dan, I'm going to interrupt you because you're not actually answering my question. You're doing a monologue.
The reason I'm making a record, Commissioner Williams, is because I want.
But we're not in we're in deliberation by the board, and I posed a question to you.
The question you asked me was, what would the applicant prefer?
No, would you? I gave 3 options.
What the applicant would prefer is a clear statement from this board that despite the fact that the applicant has met all of the requirements in the code in order to get preliminary plat approval, to then address the issues raised by 2 of the commissioners before you actually give an up or down decision, because that's what the applicant is going to be requesting. The reason we want that clarity is because if we need to litigate this, and we likely will if there's a denial, we need to have a clear record as to why you're doing this. And so what we would like is an up or down vote with clarity that we have met all the requirements, and that despite that, you're still denying the application for preliminary plat.
Okay, thank you.
Thank you.
All right, given the position of the applicant, Does the board want to do the full deliberation today, given that we are at 2:39 from the worksheet? Or do you want to pend the way we have done other worksheets and then just do a day where it's just going through the worksheet itself?
I think
There
we owe it
is-
to the applicants to go ahead and give them an answer.
I think we should use the time we have to see if we can get to the up or down decision that's been requested.
Okay. So with that, we will start. (12-268), application process, general provisions, agency routing.
I found that it complies, and I would adopt the staff report.
Commissioner Domke?
I concur. Actually, sorry, I need to pause. Concur.
All right, 12-412, density and dimension standard suburban zone, minimum lot size required is 1 acre for the suburban S district where urban water services is provided.
I find that this complies, and I would adopt the staff report.
Concur.
All right. 12-610.b, conformance with BCRC Title 12, minimum lot size required is 1 acre for the suburban S district where urban water services is provided.
I found that this complies, and I would adopt the staff report.
Concur.
12-620, general easements, constraints, reserved land areas to be shown and marked on the plats.
I found that this complies, and I would adopt the staff report.
I have a dissenting opinion on this one. I believe not knowing the floodplain condition is a constraint that is not identified at this time. Further discussion on the record.
That was 12-5, 12-14, sorry. 12-621, lot design, all proposed lots or parcels which are 300 feet, 300 or less in width shall maintain a depth to width ratio of not greater than 3.2 to 1, and lots which are more than 300 feet in width shall maintain a depth to width ratio of no greater than 4.2 to 1. All proposed lots or parcels 100 feet or less in width shall be designed so that the angle of intersection of the sidelines with the fronting road is between 85 and 95 degrees for a distance of not less than 50 feet from the point of intersection. Submerged lands are not to be included in this determination.
I found this complies, and I would adopt the staff report.
Commissioner Domke?
Yeah, I'm trying to ascertain, I decide, given the submerged lands aspect. No, I'm sorry, that's right, that works within the
That works.
floodplain. So I concur.
to 12-622, submerged lands not to be counted toward density calculations.
I found this complies, and I would adopt the staff report.
Concur.
12-623A, urban services, urban water is required for lots under 2.5 acres but equal to or greater than 1 acre.
I found this complies, and I would adopt the staff report.
Concur.
12-623B, water supply, lots to be served by Syringa Heights Water District.
I found that this complies, and I would adopt the staff report.
Concur.
12-623C, sewage disposal method is proposed to be individual septic system.
I found that this complies, and I would adopt the staff report.
Concur based on the conditions of approval.
I added that, noting that the sanitary restriction lift must include the space for signature as indicated in that staff report. 12-623D, fire plan, fire assessment of fire risk, fire protection plan, defensible space plan.
I found that this complies, and I would adopt the staff report.
I'm going to concur with the comment that I find the letter from the fire district to be confusing because it seems to contradict itself. However, the fact that they signed off on the variance, I'm going to assume to be,
On that one, are you referring to that line where he says, "We continue to be concerned about the amount of development in Bonner County while not addressing infrastructure"? Is it that later?
Because there's a comment that they can't.
We do not have adequate fire resources to protect this subdivision.
Yes, so
Is stated in that.
So we don't have adequate resources to protect this subdivision, and yet, so it's not a generic statement, and yet they've essentially said, yes, we can, through agreeing to a variance with a water tank location. So by agreeing to a variance, I'm going to land on the side of they are agreeing, but they have offered a contradictory comment at the end, which
that was one where I had questions on when I read it, and I wasn't part of that aspect because I couldn't tell if what they say is they reached an agreement to provide the IFC variance that allow for the single large tank for water storage, an option that will allow for easier access to water in the event of an incident, but equally saying that they do not have adequate fire resources to protect the subdivision, this subdivision being specific to this development. And I was conflicted on how you answer that question because it sounds like this is the best of what you can do, but we can't help you. And so does that count as adequate? I took the chief's statement on the end to say there is not adequate fire resources to protect this subdivision. And that's what I put in because that's what he wrote, even though he made the comment that he gave the variance.
Yeah,
and I wasn't there to kind of go back and forth on that, but I had an issue with his language.
So that's where I'm going to say yes, because he's issuing the variance. While I find the can't provide protection for the subdivision comment to be contradictory, if I take that in context of lack of adequate resources, then I guess that would mean that there's no subdivision or area of the county that they have adequate resources within their district to provide coverage for, and therefore we wouldn't be able to, we'd have to have a moratorium on all construction in the county within their district. It just, I don't think that's a reasonable approach, so I'm going to disregard that part of the comment.
Okay. 12624, road name, unique road names for new roads.
I found this complies and adopt the staff report.
Concur.
12624B, road standards, roads to be designed to meet private road standards of the BCRC Title 12 Appendix A.
I found that this complies and adopt the staff report.
Concur.
I have to ask for a clarifying only on was the road and bridge comment saying that something on the plat needed to be identified as public that was listed as private? I was not, the way that he wrote the comment wasn't clear to me, if that needed to be addressed.
Let me go look at the plat again. I think that was addressed by the updated plat for the prior hearing, but I need to.
It said, the way he worded it says, on the plat, show Peninsula Road as a county-maintained public road, show the right-of-way width appears to be 60, and add a note regarding how the right-of-way was established, instrument number. So that was just, I went through and made that comment of, was that something that we needed to address?
Did you say Peninsula Road?
Yeah, that's what he says in the comment. You know, actually, I think he put the comment in it's in the wrong file because it says Short
Yeah.
Platte River Estates.
Yeah, yep, that was my recollection. Didn't apply to this file.
So we'll probably have to remove that. It's in this one with that number, but a different name. All right, thank you. All right, 12624C, legal access to each proposed lot.
I found this complies and adopt the staff report.
12624D, public frontage road for lots less than 5 acres in size, direct frontage and direct access to the public roads required.
I found that this complies and adopt a staff report.
12625, trails and parks, Bonner County Trails Plan, public access parks and facilities.
I found that this complies and adopt a staff report.
12626A, natural hazard subdivisions to be designed around identified natural hazards.
I found that this complies and adopt a staff report.
I need to pause on this one.
I put a portion is located within the phone flood zone as per the firm. And then noted, kind of similar to that the LOMC/LOMR is pending in the parcel. That this and so I put that in this section as this has not been mitigated because the answer is pending.
Yeah,
At FEMA.
I agree with that perspective.
So that's what I put on there. Let me make sure. And then approval of compliance with BCRC Title 14, 1501 L through O. I noted in that box as well. 12626B, conformance with BCRC 12-7, conformance with environmental standards.
I found that this is in compliance and adopt a staff report.
Sorry, movement through the
Yeah,
internet slowed down for a
it's,
second for some
the
reason.
codifier is slow.
I had some questions when it came to hard to know this answer pending the response from FEMA on part of this project. Because I felt there was information missing with respect to the environmental factor of the water on the property.
Yeah, part of that for me goes back to also the stormwater management plan. It's unknown as to the viability of it without knowing the base flood elevation question, having that answered, so. Looking at
127241 was in part what's referenced for me in that section. That is specifically the stormwater management plan inside the Chapter 7 environmental standard. Anything further on that?
No, I think that's all for that one.
12642A, application content, application form.
I found that this complies and adopt a staff report.
I think on this one, there was quite a few amendments with submission of information that wasn't given at the original. And I think I have a difference of opinion than, it isn't just that we receive it, but is everything received on applications. I think in the end, information was given, but in part also part of the information that has been asked for hasn't been received.
Yeah, for me, I'm gonna I'd say yes on the form. It's going to be about the plat content itself for me.
For some reason, I thought on this one, I want to make sure I don't say the wrong way, that there was a couple of iterations with submissions of information that was added that wasn't received. Okay. Plat content 12642B.1 subdivision name, geographic grid, north arrow, and vicinity map, vicinity road pattern.
I found that this complies and adopt the staff report.
Concur.
Did we skip 642B or did I just not mark that off?
I think you didn't mark it off.
Okay.
12642B2 plat content, boundary line of tract to be subdivided, intersection property lines, abutting roads, names and addresses of adjoining owners shown in their respective places.
I found that this complies and adopt the staff report.
Concur.
So at some point, they weren't, and then we added it in. But I noted it's there.
Updated plat.
It's updated.
Yes.
12642B3 plat content, location, dimensions, and area of proposed lots, lot numbering.
I found that this complies and adopt the staff report.
Concur.
12642B4 plat content, location, dimensions, and tentative names of proposed streets and roads.
I found that this complies and I would adopt the staff report.
Concur.
12642B6 plat content, location of water courses, floodplains per firms with BFEs.
I found that this complies and adopt the staff report.
So we just did 5.5?
.5.
Oh, we skipped that. Did you guys both mark off B.5?
What's that?
Did you both mark off B.5?
That's the one we just did, I thought. Plat
Okay,
content.
just wanted to wanted to double check. Well, there's a lot of plat contents.
Yes.
Yep.
Contours?
Contours.
Okay.
Any issue? Commissioner Domke?
No.
Okay, 12642B6 plat content, location of water courses, floodplains per firms with BFEs.
I found that this complies and adopt the staff report.
Good dissenting opinion, we go back to the codes.
I put forward that the information hasn't been received because in part that the applicant is attempting to have it removed or amended, and the information has not been received from FEMA at this time to answer 12642B6. And then I put a comment on BCRC Title 14, 501 L through O in this section as well.
So this part of the code, floodplains as delineated on flood insurance rate maps or base flood elevations. What I heard during comment period was that what was shown on the preliminary plat was not consistent with flood insurance rate maps. So I guess that's a no. For me.
12642B7 plat content, existing wells, springs, wetland boundaries, wetland delineations, drainage channels, overhead and underground utility lines, structures, sanitary sewers, and culverts within the tract.
I found that this complies and adopt the staff report.
Concur?
I gave a comment just as to, there was comment made in the record about PhD and where septic sites and public comment on that. I just put a comment in that section on that. 12.6.
Sorry,
Go ahead.
so that you were,
I just put a comment on that, noting that there were septic concerns raised when it came to 12642B7. I think the zoning commission also noted that in their review. 12642B8, plat content, proposed method of water supply, sewage, and solid waste disposal.
I found that this complies and adopt a staff report.
Concur.
12642B9, plat content, all easements of record including sufficient data to identify conveyance.
I found that this complies and adopt a staff report.
Concur.
12642B10, plat content, purpose indication for parcels reserved for public dedication or common use of property owners.
I found that this complies and adopt the staff report.
Concur.
12642B11, plat content, statement for intended use of lots.
I found that this complies and adopt the staff report.
Concur.
12642C2, road design and profile, preliminary road design and profile prepared, stamped, and signed by Idaho licensed engineer.
I found that this complies and adopt the staff report.
12643A, in accord with 12268.
I found that this complies and adopt the staff report.
I need to reference that again.
I was pausing to go back.
I concur.
Okay. 12263B, public hearing in accordance with 12268.
I found that this complies and adopt the staff report.
12643I, validity of, oh, sorry, I went too fast. 12643I, validity of preliminary plat.
I found that this complies and adopt the staff report.
I need to reference that. And the internet's. Concur.
12644, improvements plan to be prepared by a registered civil engineer, 2 copies to be provided.
I found that this complies and adopt the staff report.
Concur.
12645, standards of review.
I found that this complies and adopt the staff report.
Concur.
12646, final plat contents.
I found that this complies and adopt the staff report.
Concur.
The way I wrote it was just not applicable
Yeah,
at this stage.
I agree with the staff report because they said it's not applicable.
12647, there's just 70 pages. 12647, endorsement on final plat.
I found that this complies and adopt the staff report.
127.1, oh, sorry. You gotta come with that comment.
I told her with that speed.
I forgot. 127.1, shorelines.
I found that this complies and adopt the staff report.
I just want to confirm shorelines don't apply to flood zone.
Streams apply in that situation.
Yeah, but not flood zones, correct? Thank you. Oh, you said pretty sure.
I know, they gave us,
It's all over.
I know, it's,
Checking now.
I thought this concurred though.
I think it does. I just need to confirm my understanding of the definition of shorelines.
It's the hydrology.
Yeah, lakes, sloughs, ponds, or similar basins. Concur.
127.2, grading stormwater management. applicability all new subdivisions subject to the provision of the Chapter 6 of this title as amended, and new planned unit development subject to the provisions of the Chapter 2, Chapter 2.5 of this title as amended, except as provided for in subsection 12.720.3J of this subchapter.
I found that this complies and adopt the staff report.
This one is a no for me because I don't know if the current submitted plan is conforming until we understand the base flood elevation.
I had a dissenting opinion as well for the same reason. 12.7.3 wetlands, wetland delineation, wetland buffer, and setbacks.
I found that this complies and adopt the staff report.
Concur.
12.7.4 wildlife.
I found that this complies and adopt the staff report.
Concur.
12.7.6 hillsides geotechnical survey requirement.
I found that this complies and adopt the staff report.
I had dissenting pending review of the same,
Yes. Flood damage.
and storm water management. BCRC Title 14 flood damage prevention development to occur. Did I skip one? Or are you going
I
to say
thought you
something?
were on 14.
Okay. BCRC Title 14 flood damage prevention development to occur as per BCRC Title 14.
So again, lack of BFE for me is a no.
And I put a portion of the site was located in the flood zone as per the firm panel number that was provided in the file. Okay. Any further deliberation by the board? I think that was it.
Ready to go to the comp plan?
Yeah.
I missed your analysis on BCRC Title 14. So I think there was a couple of arguments that was presented that should be deliberated on by the board.
Sure.
I just said that it complies. I found that it complies.
Was that a general agreement between the whole board?
No,
I don't
the
think
comment
so.
I made was a portion of the site was located within the flood zone as per firm panel number provided in the record. That was my comment on it.
My position is that there's no data in the record to show compliance with BCRC 14-501L.
Okay.
Can the board, again, just because we want to have the reasoned decision analysis, right? Can you address the other code section that I raised, which is, what is it, 50?
Raised by the applicant.
Raised by the applicants as well?
Correct.
And please explain why the code section you just cited is, your interpretation emphasizes that one as opposed to the other, or how you view those two code sections in relation to each other.
And you want that done in the section that is titled Title 14?
It's all under Title 14.
It's, as long as it's in the reasoned decision, we can be flexible.
So from my perspective, BCRC 14-503A3 is a subservient requirement to BCRC 14-501 O and L. And I do not believe that we have information in the record that allows me to determine that the preliminary plat as presented is reasonably safe from flooding without knowing the base flood elevations.
I concur with that. I think that, I don't think there's disagreement that the record doesn't show it. There's just disagreement that whether or not you wait until you have the answer or do you approve it and move forward. And I think that that is, in part, I think that it's incumbent upon the board to interpret when you're looking at the development of the subdivision. There is no disagreement that we don't know the answer, and the applicant doesn't know the answer. The applicant understands that they're going to have to make adjustments if, in fact, the information comes back from the federal government that says, well, we can't make the adjustments that have been requested. And so for me, it's incumbent upon me to take a look at not knowing the answer to that question, and I equally agree that that is a requirement, it is our code. I can't answer that question without that answer, and I don't think that a qualifying statement works to say, assuming how the federal government would write a response to the county is not reasonable, recognizing that I understand that delays happen, but me saying yes, hoping that something is what and it's an assumption, but this is the date of the hearing, and so I understand the concerns brought forward by the applicant, but I have to be able to answer the question that's posed in the subservient title, and I don't believe that I can answer that question pending a review of FEMA to address it. And throughout this whole document, part of what we're referencing is what is the firm? What are they saying? And we don't know the answer to that question. And I don't feel compelled to make an assumption that they are the authority in this area. I need to receive the information to make a decision. And for me, a decision made that ignores that I don't have that is not a well-reasoned decision. It would be for me a decision to not slow down a development, which is not the statute. The statute isn't for me to move quickly through something. It's to be able to answer that question. And it's an unfortunate delay that's out of the control of the developer. But I think that ordinance is still a requirement that be followed.
And additionally, for me, the lack of this base flood information data doesn't tell me whether or not the proposed stormwater system is viable. Just because of the proposed location of the stormwater basin or pond, in the proximity of the floodplain and the different elevations that have been presented by the applicant leads me to believe that we don't know if it's a viable solution.
And I think I would add to that the way that the applicant proposes it, it's recognizing that it could go either way because they're giving two options. It's either to remove the site from the special hazard area or to determine the base flood elevation for the site. So it's telling you in the application that I don't know the answer to that question. And to me, that justifies my response on BCRC Title 14 flood damage prevention as written in our code, recognizing what counsel for the county has brought forward. I don't think it removes my obligation to have that answer there. Is that sufficient for you? Okay.
Did we do 12-7.6?
Yes, we just went back to Title 14. Thanks for clarifying. In my record, at least.
We did. Okay.
I don't know if Commissioner Williams has the
No,
same.
we did. We went through it. I marked it off. It was a quick one. Any further on that worksheet portion?
I think we're ready for the comp plan analysis.
Or we have to go through another 100 pages here. All right. 12268, agency routing.
I'm sorry, where are you?
Did I not go
I
to
think
the
you
next
should be in
one?
the comprehensive plan analysis now.
12-643G.
Let me go if I flipped to the wrong document and slid down. What happens when you have too many tabs open?
I can only have a dozen.
Oops, sorry. I'm gonna let someone else read since I went through all of those too, so if someone else wants to start while I open my worksheet.
Let me take it up, or do you-
We're not, are we gonna read through all of the policies?
I was just gonna say the title of each
Yep,
one if you
title.
want.
Yep.
Yes.
So 12-643G, comprehensive plan analysis. The first one is property rights.
I found that this is not in conflict and adopt the staff report.
I didn't have an issue with that.
So for me, I find that it is in conflict because of the lack of the BFE means I cannot confirm the short-term and or long-term consequences of this application.
Let me go back. I want to make sure I'm not opening the wrong thing here. I'm going to change my answer on this one. I'm opening up the wrong form. I add in that property rights to address the concerns brought forward in terms of also storm water management and impact to adjacent properties as a comment in that section.
Population.
I found that this is not in conflict and adopt the staff report.
I concur.
I found it not in conflict with the plan. I noted it was identified as an area of increased development also.
Agreed. School facilities and transportation.
I found this not to be in conflict and adopt the staff report.
I concurred.
Concur. Economic development.
I found that this is not in conflict and adopt the staff report.
I concurred.
I concur. Land use.
I found that this is not in conflict and adopt the staff report.
I had issue with adding in the same comment on the BFE issue, but noting that in terms of where we are in the comprehensive plan, that the increased development is there. I had that same concern, and then PhD.
I find it's not in conflict with the policies of the land use component.
I think I can reasonably recognize I put a little bit more concern on the land use on that section.
Natural resources.
I found that this is not in conflict and adopt the staff report.
I
Concurred.
had some wishy-washy water comments, but I could see just strictly straight across that it's in line. But I had some unknown concerns on natural resources. But
Hazardous areas.
I found that this is not in conflict and adopt the staff report.
For me, I found this to be in conflict. I could not find alignment with policies 2, 3, 5, or 6 due to the floodway development discouragement requirement, fill within. You don't have enough information to validate those at this time. 5, the excessive slopes. Again, right now with the stormwater development as proposed, and then multiple points of ingress and egress for large developments. We can debate the definition of a large development, so I could concede on 6, but 2 and 3 in particular are problematic for me.
I had similar issues. I didn't have an issue with the in and out only because I put that on the responsibility of fire and they didn't make that comment. And I believe that's within their, if I recall, that's within their requirement to give the number of in and out and the size and width of driveways. So that would be my kind of rebuttal to that, even though I equally recognize that there were people that had that as an issue in terms of mitigation. I looked at in that comment, what's required of the developer, and it wouldn't reach a requirement from them.
And for me, the words should be discouraged and should be considered. It's not shall. So
Agree.
that's that's why I found it not to be in conflict.
Yeah, I agree. It's not an imperative.
I think it
There's just
allows
too
the
much
room
lack
to
of
think
clarity
of as
for
an
me.
issue, to say that it would be more ideal given what you see. I see that as an option there.
And then you guys ready to go on to public services, facilities, and utilities?
Yes.
I found that not to be in conflict and adopt the staff report.
I concur.
I didn't see a conflict on that one.
Transportation.
I found that not to be in conflict and adopt the staff report.
I didn't find a conflict. I did note comments made about, I think there were comments about wanting a traffic study based on Bonner County Road and Bridge and not, I think also it was stated in this hearing, not liking the ITD comment, but it wasn't in conflict. Road and Bridge provided a comment and they didn't identify that as a need, so I didn't give that to it.
I agree. I did, based on public comment, I reviewed that in more detail. I agree that I couldn't find where it met the criteria for a traffic impact study. There was also a comment made about folks who speed on the road, even though it's posted as 35 miles per hour. However, that's a law enforcement issue. And actually, the trip generation report showed that the line of sight and gradient of the road per county standards actually would allow up to a 55 mile per hour speed, which I would certainly never encourage. But from a pure design perspective, the road is adequate as posted at 35 miles per hour.
Okay.
Recreation.
I found this not to be in conflict and adopt the staff report.
I didn't see a conflict.
I concur. Special areas or sites.
I found this not to be in conflict as it doesn't appear to include any special areas or sites.
I concurred.
I agree. Housing.
I found this not to be in conflict and adopt the staff report.
Concur.
No issue on that.
Community design.
I found this not to be in conflict and adopt the staff report.
I concurred.
I also agree. Agriculture.
I found this not to be in conflict as I find it not applicable and adopt the staff report.
I concurred.
As do I. And then we have conflicting evidence in the record. Did we find any? I will say that I know there were comments made by the public about opinions offered, about concerns, but I didn't see actual evidence proof presented that contradicted what we had for relevant jurisdictional agencies and their comments and feedback. So I didn't find any conflicting evidence in the record that I thought we needed to address from that perspective.
I didn't find any conflict. I think that, for me, this comes down to just information that hasn't been received at this time. But I didn't see a conflict. I did hear concerns about what people thought on this particular project.
Yes, we've talked about fire, we've talked about drainage, we've talked about Baldy Mountain Road. I'm going through my notes during public comment from the prior hearing as well. There was a comment about existing access easement, however, of an adjacent landowner, but that is a civil matter to be addressed, in my opinion. The purpose of the preliminary plat per county code is to determine if legal access exists for the proposed applicant, not for other considerations of adjoining landowners, private use. So, and there was the comment also brought up about potential nutrient load inserting a creek, but I believe we need to rely on DEQ and PhD to determine what's appropriate there. And I have notes that Mr. Pepin from PhD actually responded to that during public comment at the prior hearing. It indicated this is not an area that has been identified with the state to be further monitored. So I think it goes back into the standard PhD review.
I think that there were comments also made in the record about people having concerns of the number of septics on the lots and the permeability of the soil. But I think that also goes to a PhD review that comes at a later date. And I don't think that it was something that could be addressed in this part of it because of the process by which the county does these files. But I did see that as a concern that a number of people in the community brought up of the permeability of so many septics versus doing more of a community type system. So I did see that.
On septics, I would also like to just add that PhD did make a comment at the last hearing stating that they would prefer the applicant to do their dirt work and all before they came out and did their testing so that they could have a more accurate site testing and stuff and know where things were going to go.
All right. So we've gone through the comprehensive plan and the zone change. At this time, is the board ready to entertain a motion on this file?
I am.
Sorry, go ahead.
I am.
Okay.
But I'm not going to make the motion because I was going to delay things. So I will defer for your motion.
All right, Commissioner Domke.
Going through, looking at the motion first.
No worries.
Kind of ask a question of legal while you're working on that. If for some reason there is a split vote, is that a denial?
Well, it is if the majority denies the file.
If it's a 1-1 vote with someone abstaining?
Yeah, so let's see, this is a subdivision, so it's only a recommendation from the underlying decision maker. This is the problem that we have in our code right now that we're trying to fix. We don't have a clear authority in the code that addresses what happens when there is a 1-1 split. The way we've always theoretically approached it is that it depends on the nature of the underlying action. Sometimes you get a final decision from, say, the zoning commission that gets appealed to the Board of Commissioners, and then hypothetically, if there was a 1-1 tie, that would mean that the underlying decision would stand, whatever that is. In this case, because there's only been a recommendation, because only the board can approve this type of file, the presumption is that it would be a denial, because they are not operating from the position of an approval. They still need to secure that, and if you guys can't arrive at that solution, it does result in a denial.
Okay, thank you.
Sorry, I just have to go back through our deliberation decisions to determine how to prepare the motion.
Before we go through, because I think that we have the potential to end up doing multiple based on the conclusions that we have to physically go through, can we deliberate on the conclusions for a majority understanding of the motion? Because I think that's in part what you're looking at is where you would go. And I think that if we went through the conclusions and then had a deliberation on the majority, then we would know how to motion. Is that a good
Yeah, that's great, because
recommendation?
I just went through and highlighted.
Okay, so conclusion one says the proposed subdivision is or is not in accordance with the purposes of Title 12 and of the suburban zoning district.
So I would say that it is. I mean, from my overall perspective, it's not about the purposes of the suburban zoning district. That's the issue. So it's specific question of information to comply with other aspects. So for me, I would say it's in accord with the purposes of the suburban zoning district.
I agree with conclusion one that it is. Conclusion two is the site is or is not physically suitable for the proposed development. My problem with the way the question is posed is part of the answer is we don't know the answer because I don't have the information to say is or is not, and that's part of the problem. And so that there's insufficient information to determine that it is or is not. That's how I see conclusion number two.
I agree, so I feel I have to default to is not until I have data to say that it is.
Okay. Conclusion three, the design of the proposed subdivision will not or will adversely impact Bonner County's natural resources as identified in the comprehensive plan. Any adverse impacts or potential for impacts be mitigated as conditions of approval.
I would say will not, because it's specific to the natural resources component in the comprehensive plan. And so I believe the main issue that we addressed was the hazardous areas, not the natural resources area.
Correct. I concur with that. Conclusion four, the public and private services, including but not limited to water, sewer services, solid waste, fire protection, emergency services, and school facilities and transportation, which will serve the proposed subdivision, are or are not adequate for the needs of the future residents or users.
So for me, it's R, based again on our conclusions reached when we went through those different aspects.
I will concede that with my trepidation on the way in which Chief wrote that letter, because he specifically says something but he issued a variance. So I'll accept the variance, but I think I would like us to do a follow-up that says, read the last sentence of that note. So, conclusion 5, proposed subdivision will not or will cause circumstances to exist that will cause future residents of the public at large to be exposed to hazards to health or safety. My position on that one is the same as it is for conclusion number 2, in that I don't have the information to say that it will not.
I agree.
Conclusion number 6, the design of the proposed subdivision or related improvements will or will not provide for coordinated access with the county system of roads and with adjacent properties and will not or will impede the use of public easements for access to or through the proposed subdivision. The proposed transportation system is or is not designed to adequately and safely serve the future residents or users without adversely impacting the existing transportation system by reducing the quality or level of service or creating hazards or congestion.
Based on our prior deliberation, for me, it would be will not, and is.
That one does create a rub because there's too much in that sentence. And so my proposal would be, what if we broke out each will or will not and gave additional sentences that way? Because on some of them, I think the answer is will not. I think some were will and some, because I think there's just a lot in that conclusion. Because will it provide coordinated access with the county system of roads with
Yes, I
adjacent
believe it will.
properties? Period. Will it impede the use of public easements for access through the proposed subdivisions? Or do you want to keep it as a paragraph?
I'm okay with, I mean, I know it's a long sentence, but I'm okay with it. I think it will be coordinated with the county system of roads and it will not impede the use of public easements for access. So if you're okay with that, I can roll with it.
Okay, I'll let you roll
And I would
with
say
it.
the proposed transportation system is designed to adequately and safely serve the future residents.
Okay. Conclusion 7, the proposed subdivision is or is not designed to comply with the design criteria for subdivision set forth in subchapter 6.2 of this chapter.
For me, it's not for the same reasons of lack of confirming information.
Okay. Conclusion 8, the proposed subdivision is or is not in conflict with the policies of the Bonner County Comprehensive Plan.
For me, it is particularly because of the hazardous areas.
Okay.
Bill, can I ask you, do you need my input on any of these questions, or are you okay with the two other commissioners?
It looks like the way the motion is going and the way that Brian is getting ready to make a motion, that the majority agrees with this.
Okay.
You are free to add or not add whatever you feel is relevant to the deliberation.
Yeah, and I apologize. I wasn't intending to keep you on. I thought you just didn't want to participate in this part since we were moving in a different direction.
Right, and then I'm kind of thinking about it. It's like,
Yeah.
well, maybe my input should be on the record as well.
Your input
If you-
should
yeah,
be on the
absolutely.
record.
If you have input you want to give, I think that's good.
So
Well,
real
we-
briefly, I'm just going to cite the conclusions and my response.
One
to
second
make it
here, though.
simple.
So what we did was, we went through how he's going to make the motion, because he's going to read from top to bottom on the motion. And then to make it as seamless, when he reads one of the conclusions, and we'll pause for a dissenting opinion so that your opinion's on the record. But this way, we don't end up with a motion that's fractured based on seeing the way the majority of the board is going. There are so many conclusions where there were yes and no's, so that he reads it straight through.
Or when the motion is made and you guys deliberate on the motion itself, that could also be the time that you just say, this is why I object to the motion on these grounds. Also an appropriate place to make that comment.
Okay.
I'll just suggest it might be a little cleaner if I can just read through the motion, and then if during deliberation, if you want to step through each one versus pausing and going back and forth, if that's agreeable.
Either or.
At any point in time, I just think it might be best to put it on the record.
Yeah, I think that's a good idea.
All right, at this time, we'll entertain a motion.
I move to deny this project file S0001-25 Deerfield subdivision, requesting the creation of 24 residential lots in one stormwater tract on an approximately 32.67 acre property zoned suburban and located in section 618, township 57 north, range 2 west, Boise Meridian, Bonner County, Idaho. Says it twice. Based upon the following conclusions. Conclusion 1, the proposed subdivision is in accord with the purposes of Title 12 in the suburban zoning district. Conclusion 2, the site is not physically suitable for the proposed development. Conclusion 3, design of the proposed subdivision will not adversely impact Bonner County's natural resources as identified in the comprehensive plan. Any adverse impacts or potential for impact shall be mitigated as a condition of approval. Conclusion 4, The public and private services, including but not limited to water, sewer services, solid waste, fire protection, emergency services, and school facilities and transportation will serve the proposed subdivision are adequate for the needs of future residents or users. Conclusion 5, the proposed subdivision will cause circumstances to exist that will cause the future residents or the public at large to be exposed to hazards to health or safety. Conclusion 6, the design of the proposed subdivision or related improvements will provide for coordinated access with the county system of roads and with adjacent properties and will not impede the use of public easements for access to or through the proposed subdivision. The proposed transportation system is designed to adequately and safely serve the future residents or users without adversely impacting the existing transportation system by reducing the quality or level of service or creating hazards or congestion. Conclusion 7, the proposed subdivision is not designed to comply with the design criteria for subdivisions set forth in subchapter 6.2 of this chapter. Conclusion 8, the proposed subdivision is in conflict with the policies of the Bonner County Comprehensive Plan. The recommendation is based upon the evidence submitted up to the time the staff report was prepared, the testimony received at this hearing. I further move to adopt the reasoned statement as discussed in deliberation at this hearing and the analysis as set forth in the staff report or as amended during this hearing, and direct planning staff to draft the reasoned statement to reflect this motion as set forth in Idaho Code, section 67-6535, have the chair sign and transmit to all interested parties. This action does not result in a taking of private property.
I will second that to further deliberation.
All right, there's a motion and a second. Deliberation by the board.
So I have a consenting opinion, starting with conclusion 2. I think that the site is physically suitable for the proposed development. Conclusion number 5, the proposed subdivision will not cause circumstances to exist that will cause future residents or the public at large to be exposed to hazards to health or safety. Conclusion number 7, the proposed subdivision is designed to comply with the design criteria for subdivisions set forth in subchapter 6.2 of this chapter. And conclusion number 8, the proposed subdivision is not in conflict with the policies of the Bonner County Comprehensive Plan. Those are the conclusions that I have consenting opinions on.
Dissenting.
Dissenting. Ascending.
For me, I think one of the things that, and I think it comes in that the last paragraph is based upon the evidence submitted, and I don't have the evidence to otherwise address the concern that addresses the stormwater and the flooding issue. And to me, that's part of the issue here, and following through with the zoning requirements and the review of it. I understand the hardship on the developer for not having that, and it comes from the federal government, but it doesn't change that I don't have the answer to say the yeses. They would be assumptions based on a hope with recognition that there is a point of recognition that the ability to know what's going on and for the community to give input goes away after we're finished with this as well. And there's no comment given on that. And some things can change very significantly. And our job is to look at the project and the impact, not just to the developer side, but also to the public around it. And I'll be honest, if they come back and this comes through, I mean, we've said yes to most of this. There's information that's not there. And I think that it doesn't mean you'll like the decision that gets made. It means this might just be a roadblock because it's not here. But their application addresses a good amount of it. It's just there's a piece that's not here for me to change those answers to yes on. And that's the way the code is written in Bonner County. So I just want to give that comment. So anyhow, further deliberation by the board?
None.
All right, roll call vote.
Commissioner Ford?
No?
Commissioner Donkey?
Yes.
Commissioner Williams?
Yes. Motion passes. It is 3:44 and this meeting is adjourned.